Alright, Labor Management Report Disclosure Act of 1959 is amended. Alright, Title 3, Trusteeship, Section 301. Title 29 U.S. Standard Code 461, Section 301. Every labor organization which has assumed the trusteeship over any subordinate labor organization shall file with the Secretary 30 days after the date of enactment of its imposition, any such trustee semi-annual thereafter, report signed by its president and treasurer corresponding with the principal office as well as the trustee such subordinate labor organization containing the following information: 1. Name and address of the subordinate organization. 2. The date of establishment of the trusteeship. 3. The detailed statement of the reason for the establishment continuing with the trusteeship. Nature extent of the participation by the membership of the subordinate organization, selecting delegates to represent such organization in regular special conventions, other policy determined bodies, and election officers, labor organization which assume the trusteeship over the subordinate organization. The initial report shall include a full, complete account of the financial condition of the subordinate organization as of full-time trusteeship was assumed over it. During the continuancy of the trusteeship of labor organization which has the assumed trusteeship over such subordinate labor organization shall file on the behalf of the subordinate labor organization with the annual financial report required by the Section 201B, signed by the President and Treasurer corresponding principal officer for the labor organization which assumed such trusteeship of the trustors of the subordinate labor organization. B. The provisions of Section 201, C, 205, 206, 208, and 210 shall be applicable to reports under the file. C. Any person who willfully violates this section shall be fined not more than $10,000 in prison for not more than 1 year or both. D. Any person who makes a false statement, representation, material fact, and known to be the false will knowingly fail to disclose the material fact in any report required under the provisions of this section, willfully makes any false entry, willfully withholds and conceals, destroys documents, books, records, reports, statements upon the report is based, and shall be fined at $10,000 in prison for no more than 1 year both. Each individual required to support the signing and report under the section shall be personally responsible for filing such report for any statement containing therein which is known to be false. Our purpose of which trusteeship may be established. Title 29 U.S. Standard Code 462, Section 302. Trusteeship shall be established administrated by the labor organization subordinate body in accordance with the Constitution and bylaws of the organization which assume the trusteeship over the subordinate body for the purpose of correcting corruption and financial malpractice, ensuring the performance of collective bargaining agreements, other duties of the bargaining representative, restoring democratic procedures, and otherwise carrying out legitimate objects of such labor organization. Alright, unlawful acts relating to labor organization under the trusteeship. Title 29 U.S. Senate Code 463. Section 303. A. During any period of the subordinate body of the labor organization, trusteeship shall be unlawful to 1. To count the vote of the delegates for the such body convention or elections of an officer of the labor organization unless the delegates have been chosen with secret ballot in any election in which all the members of good standing with such subordinate body were eligible to participate. 2. The transfer of such organization any any current receipts or other fines for the subordinate except for the normal capital tax and assessment payable with the subordinate bodies and the trustee provided with a herein contained to prevent the distribution and have assets in labor organization in accordance with the Constitution, bylaws upon bona fide dissolution thereof. B. Any person who willfully violates this section shall be fined not more than $10,000 in prison, not more than 1 year or both. Enforcement. Title 29 U.S. Standard Code 464, Section 304A. Upon the written completion of any member subordinate of the body of the labor organization alleging the organization validated with the provision of the title exempt with the Section 301, the Secretary will investigate the complaint and Secretary finds probable cause to believe that such violation has occurred that has not been remedied as she shall, with the closure of the identity of the complaint, bring the civil action in the district court of the United States having jurisdiction labor organization for such relief, including injunctions as may be appropriate. Any member of subordinate body of labor organization affecting by any violation of the title except the Section 301 may bring a civil action in any district court of the United States having jurisdiction of the labor organization for such relief, including injunctions as may be appropriate. B. For the purpose of an action under the section, district courts of the United States shall deem that they have the jurisdiction of a labor organization, 1. In the district in which the principal office of such labor organization is located, or 2. Any district in which the duly authorized officers or agents engage in conducting affairs of trusteeship. See, any proceeding pursuant to the section trusteeship established by the labor organization conformity with the procedural requirements and constitution bylaws authorized ratified after the hearing, fair hearing either before or executive board before such of the body as provided within accordance with the constitution bylaws shall be presumed with valid for a period of 18 months from the date of the establishment shall not be subject to attack during such period except upon clear convincing proof of the trusteeship was not established maintained with good faith for the purpose of allowable under section 302. After the expiration of 18 months, the trusteeship shall be presumed invalid. Any such proceeding discontinuities shall be decreased unless the labor organization shall show the clear and convincing proof of the continuation of the trusteeship necessary for the purpose allowable under section 302. In the later event, with the court may be disclosed, dismissed, and complaint with the retaining jurisdiction of the case in such conditions for such period it deems appropriate. Alright, report to Congress. Title 29 U.S. Senate Code 465, Section 305. The Secretary shall submit the Congress expiration of 3 years over the date of the enactment of this act, reporting upon the operation of the titles. Complaint by the Secretary. Title 29 U.S. Senate Code 466, Section 306. The right to remedy provided that this title shall have the additional any and all other rights, remedies, and laws in equity provided that upon the filing of a complaint, the Secretary of Jurisdiction District Court over such a trusteeship shall exclusively final judgment of the be res judicata. Title 4, Election. Terms of office election procedure. Title 29 U.S. Senate Code 481, Section 401A. Every national international labor organization, except for the Federation National International Labor Organization, shall select an officer not less than one every 5 years, either the secret ballot among the members in good standing conventional delegates choosing by secret ballot. Every local labor organization shall elect the officers not less than often but once every 3 years by selecting ballot among the members of the good standing. C. Every nation in the International Labor Organization, except for the Federation of National International Labor Organization, every local organization and its officers shall be under the duty and enforcing any suit of the bona fide candidate in the office in such labor organization, the district office of the United States in which such labor organization maintains a principal office to comply with the reasonable request of any condition to distribute by mail or candidacy. Mail or otherwise candidate expense campaign literature in aid of the such person candidacy to all the members in good standing of such labor organization to refrain with the discrimination in the favor of against any candidate with respect to the use of the list of members whenever the such labor organization or its officers behave in the distribution by mail otherwise the members campaign literature on the behalf of any candidate labor organization itself reference to selection such election and similar distribution of requests of any other bona fide candidates shall be made with the budget by such labor organization officer. The equal treatment is expensive for such distribution. Every bona fide candidate shall have the right, once and within 30 days prior to the election of labor organization in which he is a candidate, inspect the list containing the names and last known addresses of all the members of the labor organization who are subject to election, collective bargaining agreement with the membership thereof, and a condition of the employment which the list shall be maintained and kept in the principal office of such labor organization designated an official thereof. Adequate safeguard to ensure that fair election shall be provided, including the right of any of the candidate to have and observe the polls and counting the ballots. Alright, do officers and intermediate bodies such as general committees, system boards, joint council shall be elected not less than once every 4 years by secret ballot among the members of the good standing of the labor organization officer representation of such members who have been elected with the secret ballot. In any election required by this section which was held with the secret ballot with a reasonable opportunity shall give the nomination for the candidates. Every member of the good standing shall be eligible candidate to hold the offices in subject section 504. Reasonable qualifications uniformly imposed shall have the right to vote and otherwise support the candidates of the choice without being subject to penalty, discipline, or improper interference or reprisal of any kind with such organization, any member thereof, not less than 15 days prior to the election, north thereof, shall be mailed with each of the member his last known home address. Each member is a good standing shall be entitled to one vote. No member whose duty has been within his employer the payment of such organization pursuant to the voluntary authorization provided with a collective bargaining agreement shall be declared ineligible to vote or be candidate of the office in such organization by reason of the delay of the default of payment of dues. The votes can be cast by the members of each of the labor organizations shall be counted and resulted and published separately. The election of officials designated in constitutional bylaws and Secretary in those office, and if no other official designated shall preserve 1 year of the ballots and all other recordings pertaining Heading to the election. The election should be conducted in accordance with the Constitution, bylaws, and such organization insofar as they are not inconsistent with the provision of this title. Alright, F. When officers are chosen, convention delegates elected with a secret ballot convention shall be conducted in accordance with the Constitution, bylaws, of the labor organization insofar that they are not inconsistent with the provision of the title. The official designated with the Constitution, bylaws, secretary that no longer designated shall preserve 1 year credentials of the delegates, all minutes of the recorder's conventional pertaining to the election of office. No monies received for the labor organization by way of the dues, assessment, similar levy. No money to the employer shall be contributed or applied to promote candidacy. Any of the person election subject to the provision of the title. Such money or labor organization may be utilized. No notices for actual statements of the issue involving candidates, other expenses necessary for holding the election. H. If the Secretary, upon application of any of the member local labor organization, finds an hearing in accordance with the Administrative Procedure Act, the constitutional bylaws of such a labor organization do not provide an adequate procedure for the removal of any elected officer guilty or serious in his conduct, such officers may be removed for such cause chosen after notice of the hearing by the members of good standing voting in the secret ballot conducted by officers of such labor organization in accordance with the Constitution and bylaws insofar that not inconsistent with the provision of the title. The Secretary shall promulgate the rules and regulations prescribing the minimum standard procedures determining the adequacy of the removal procedure reference made in the subsection H. Alright, enforcement. Title 29 U.S. Standard Code 482, Section 402. Any member of the labor organization who has exhaustive remedies available for the Constitution, bylaws of such organization and or parent body, and 2, and who has invoked such available remedies without obtaining a final decision within 3 calendar months after the invocation. Many may file for complaint of the Secretary with 1 calendar month thereof, alleging the violation of provisions Section 401, including the violation of Constitution, bylaws, labor organization pertaining to the election, removal of the officer. The challenged election shall be presumed valid pending of the final decision, and here within provided with the interim affairs for the organization shall conduct with the officers elected within such other manners as to constitute bylaws and may provide. The Secretary shall investigate such complaint that finds the problem causing believing the violation of the title has occurred but not been remedied shall, and within 60 days after filing such complaint, bring in a civil action among the labor organization and any of the district court and the United States in such a labor organization maintains the principal office to set aside the invalid election, and if any of the direct conduct of the election and the hearing of the voting of the removal officers under the supervision of the Secretary in accordance with the provision of the title, such rules and regulations at the Secretary may prescribe, the court shall have the power to take such action and deem properly with preserve the assets of the labor organization. See if upon preponderance of the evidence after the trial upon the merits of the court finds 1. That the election has not been held with the time prescribed by Section 401. 2. The violation of Section 401 may be effective with the outcome of the election. The court shall declare the election, if any of the voided with directly conduct with the new election supervision secretary so far as lawful, practicable in conformity with the Constitution and bylaws of the labor organization. Secretary shall promptly certify with the court of the names of the persons elected and the court shall thereupon with the decree declare such person to be officer of the labor organization. If proceeding is so for removal of the officers pursuant to subsection H and if the Section 401, the Secretary will certify results of the vote in court shall enter the decree declaring which such persons have removed officers of the labor organization. D. Any order of election dismissing complaint with the designation election elected officers of the labor organization shall be applicable to the same in a final judgment and a civil action, but any order directing an election shall not be stayed pending appeal. Applications of other laws, Title 29 U.S. Standard Code 483, Section 403. No labor organization shall be required by the law to conduct elections of the officers with great frequency in the different form of the manner that is required by its own Constitution, by laws, except for the otherwise provided with this. Shall accept the existing rights and remedies to enforce the Constitution and bylaws of the labor organization with respect to the elections prior to the conducting, that there shall not be affected by the provisions of the title. The remedy provided by this title for the challenging an election already conducted shall be exclusive. Our effective date, Title 29 U.S. Standard Code 484, Section 404. The provision of the titles shall become applicable 90 days after the date of enactment of this act, if the labor organization constituted by laws lawfully noted, modified, and amended the action constitute officers governing body, where the such modification can only be with the constitutional convention of the labor organization, not later than the new constitution convention of such labor organization after the date of the enactment of this act. 1 year after such date, whichever the sooner it is, no such convention is held with 1 year period. The executive board, similar governing body, empowered to act with the labor organization between the conventions, and empowered to make such interim constitutional changes that are necessary to carry out the provision of this title. Alright, Title 5, Safeguarding for the Labor Organization, Fiduciary Relations, Responsibility for the Officer of the Labor Organization, Title 29 U.S. Standard Code 501, Section A. The officers, agents, shop stewards, or other representative of the labor organization occupies the position of the truly relationship with such organization and member of the group. If there is a duty of each of the such person taking into account the special problems function of the labor organization to hold the money properly solely for the benefit of the organization and its members to manage, invest, and expand with the same in accordance with the Constitution and bylaws, any resolution of the governing bodies adopted thereunder to refrain from dealing with such organization adverse party for the behalf of the adverse party within any matter condition connected with the duties from the holding accuracy, pecuniary or personal interest with the conflicts with the interest of such organization to account with the organization over the profit received by him with the capacity of the connection and transaction conducted by him under the direction of the behalf of the organization, general explanation provision of the Constitution, bylaws of such organization, and a general exploratory resolution of the governing bodies purporting to relieve any of such person liability or breach of the duties declared in the section shall be voided against public policy. B. When officers, agents, shop steward, representative of the labor organization alleged for the vote violated the duties declared of the subsection A, and the labor organization governing board of the officers refused to fail to sue the recovered documents secured account with appropriate relief with a relative responsible time after being requested to do so. The member of the labor organization, such member, and sue such officer, agent, shop steward, representative of any of the district court of the United States and the state of the court, the competent jurisdiction, recovery damage, or secure and account with the other appropriate relief for the benefit of the labor organization. No such proceedings shall be brought except for the leave of the court obtained upon verified application and good showing that the application may be in the ex parte of the trial. Judge may allot the reasonable part of the recovery in any action under the subsections and pay the fees for the counsel, prosecution, suit for the instance member of the labor organization, compensate such members for any expense for the necessarily paid incurred by him in connection with litigation. C. Any person who embezzles, steals, unlawfully, willfully, abstracts, converts to his own use or the use of another any money, funds, secretary, property, or other assets of the labor organization which he is an officer or by which is employed directly and indirectly shall be fined not more than $10,000 in prison, not more than 5 years, or both. Alright, bonding. Title 29 U.S. Standard Code 502, Section 502A. Every officer, agent, shop steward, or other representative of the employee labor organization other than the labor organization whose property and annual finance report does not exceed $5,000 in value of the daily trust and the labor organization interested who handles funds and other property there shall be provided to provide protection against loss of reason of act of fraud, dishonesty, and has directly throughout the conveniency with others. The bond of each such person shall be fixed from the beginning of the organization fiscal year shall be an amount of not less than 10% of the centum of the full funds handed by the hand of the predecessor for the predecessors. If during the presiding fiscal year, but no case more than $500,000 if the labor organization with the trust of the labor organization is interested does not have the preceding financial fiscal year of the amount of the bond, but there shall be in the case of the local labor organization not less than $1,000. In the case of any labor organization of the trust and labor organization interested not less than $10,000. Such bonds there shall be the individual schedule and form shall have the corporate security company as surety thereon. Any person who is not covered by such bonds not be permitted to receive, handle, disburse, other exercise custody and control of the funds or other property of the labor organization of the trust in which the labor organization is interested. No such bond shall be placed through an agent or broker with security company within which the labor organization, officer, agent, shop steward, or other representative of the labor organization has any direct, indirect interest. Such surety of the company shall have the corporate surety with the whole of the grant authority with the secretary of the Treasury under the Act of July 30th, 1947, entitled 6 U.S. Standard Code 613 as applicable surety of the federal bonds. Provided that, where in the option the Secretary of Labor Organization has made the binding of the arrangement that would be provided with the protection required by the section comparable to the loss, cost and less, and has made exempt such labor organization from placing a bond through the surety of the company holding such grant authority. B. Any person who willfully violates the section shall be fined not more than $10,000 in prison, not more than 1 year, or both. Alright, making loans and payment of fines. Title 29 U.S. Standard Code 503, Section 503A. No labor organization shall directly or indirectly any of the loans or loans to officers or employees of such organization result with a total indebtedness of the part of such officer or employee with the labor organization not in excess of $2,000. No labor organization employer shall directly or indirectly pay the fine of any officer or employer convicted with any lawful, willful violation of the Act. Any person who willfully violates the section shall be fined not more than $5,000 in prison for not more than 1 year, both. Alright, prohibition against certain person holding office. Title 29 U.S. Standard Code 504. 504A. No person who has been member of the Communist Party who has ever been convicted or served any part of the prison term resulting from the conviction, robbery, bribery, extortion, embezzlement, grand larceny, burglary, arson, violation, narcotics laws, murder, rape, assault, with intent to kill, assault with inflicts the grievous bodily injury, a violation of Title 2, the Title 3 of this Act, or any felony involving the abuse and misuse of such person, a position, employment, labor organization, employee, benefit to seek, obtain, an illegal gain for the expense of the members of the labor organization for the beneficiaries of an employee, benefit for the conspiracy to commit such any crime, such crimes, attempt to commit any such crimes, or a crime which any of the foregoing crimes as an element shall serve the permitted to serve. 1. As a consultant with the advisor to the labor organization. 2. An officer directly trusting member of any executive board of the similar governing body, business agent, manager, organization, employee, representative in any capacity, any labor organizations. And 3. Any as labor relations consultant, advisor, person who engaged in an industry actively affecting commerce as an officer, director, agent, employee with any of the group associating with the employer, dealing with any labor organization, in positions having specific collection, bargaining authority, direct responsibility, area labor management relations, and any corporation, association engaged in any industry activity in commerce. Form the position entitled to the occupant with a share of the proceeds of an officer, executive, administrative employee of the entitled to and any with the activities in a whole substantial part of the devoted with the providing goods and services in labor organization. 5. If in any capacity other than the capacity of member of such labor organization involved with decision-making authority concerning the decision-making authority over the custody of the control of the money, funds, and assets, property within any labor organization during of the period of 13 years after such a conviction, after the end of such imprisonment, which is later, unless the sentencing of the court on the motion of the person convicted with a lesser period of at least 3 years after such conviction, after the end of such imprisonment, which ever is later, unless prior to the end of such period. In this case, the person so convicted with the imprisoned, A, had citizen rights that have been revoked as a result of such conviction have been fully restored. B, if the office of federal offense sentence judge the office of the state and local office of the United States District Court for the district in which the offense committed with the pursuant to sentence guidance policy statements under the section 994A, Title 28, U.S. Senate Code Administrative, determines that the such person serves in the capacity referred to in Clause 1 through 5 were not contrary purposes of the Act. Prior to making such a determination, the court shall have the hearing, shall give the notice of such proceeding certified mail to the Secretary of Labor, State, and the county of the federal prosecution official in the jurisdiction in which such person was convicted. The court determination any such proceeding shall be final. No person knowingly hiring, retaining, employee, and otherwise placing any other person to serve in any capacity violation subsection. B. Any person who willfully violates the section shall be fined not more than $10,000 in prison, not more than 5 years, or both. For the purpose of this section, any person who is deemed to have been convicted under the disability conviction from the day of the judgment in the trial court, regardless of whether the judgment remains at their appeal, a period of parole shall not be considered with the part of the period of imprisonment. Whenever any person in the operation of the section has been buried with the office of the barred from office, the other petition of the labor organization as a result of a conviction, and 2, has filed an appeal for the conviction, any salary which would be otherwise subject person by virtue of such office or position shall be placed in escrow by an individual employer or organization responsible for the payment of such salary. Payment of such a salary or escrow will continue the duration of the appeal for the period of time during which such salary would otherwise due, whichever the period is shorter. Upon the final reversal of such a person's conviction of the appeal, the amounts for the escrow shall be paid to such a person. Upon the final sustaining of such person's conviction of the appeal, the amounts for the escrow shall be returned to the individual employer or organization responsible for payments of those amounts. Upon the final reversal of such person's conviction, such person shall be no longer barred from by state statute from assuming any position from which the person was previously barred. or amendment to Section 302 Labor Relations Act 1947. Section 505, subsection A, B, and C of Section 302 Labor Maintenance Relation Act of 1947, amended as read as follows. Section 302 shall be unlawful for the employer, association, employers of any but the person who enacts the labor relations expert, advisor, counsel to employer whichever the acts and strengths for that employer to pay, lend, or deliver them agree to pay, lend, deliver any of the money over the thing and the value. To represent to any representative of any of his employees who are employed with the industry affecting commerce. To any labor organization, any officer, employee thereof, the representative seek to represent would admit the membership of any of the employees such employer would employ in the industry affecting the commerce. 3. To employ any of the group of the committee with the employees the employer employed with the industry affecting the commerce success if they are non-compensation for the purpose of causing such employer group the commodity directly, indirectly, than influencing any other employees in the exercise the right to organize, may bargain collectively through the representative of their own choosing. 4. And to any officer in any unemployed labor organization gained by the industry affecting commerce with the intent to influence him to respect to any of his actions, decisions, duties of the representative of the employee as such officer, employee of such labor organization. B1. It shall be unlawful for any person to request, demand, receive, accept, or agree to receive or accept any payment, loan, delivery of any money other than the thing of value prohibited by subsection A. 2. It shall be unlawful to the labor organization for any person acting as an officer, agent, representative, employer of such labor organization to demand, except from the operator, any motor vehicle defined in Section 10101, Title 49, employed with the transportation, property, and commerce of the employer of such an operator, and as many of the one thing of the valuable payable such organization to an officer, agent, representative, employee thereof, as fee of charge, free of fees of charge, unloading connection with unloading the cargo of such vehicle, provided with nothing of the paragraph shall be construed to make unlawful to any payment employer and any of the employees for the compensation for their such service employees. Or C. The provision of this section shall not be applicable one with respect to any of the money or any other valuable payable to the employer to any of the employees who establish duty for the acting openly with the employer in matter of labor relations, personal, administrative, to any of the representative of the employees to any officer, employer, labor organization who also employee or the former employee such employer compensation by reason of the service of an employee of such employer. 2. The respect of the payment, delivery of any of the money or one thing of the value, satisfaction of the judgment, any court of the decision, or of the arbitrator with the impartial chairman with the uncompromised adjustment, settlement, release of any of the claim, complaint, grievance, and dispute with the absence of fraud and duress. 3. With the respect of sales, purchase, article, commodity, the prevailing marketplace, and the regular course of the business. 4. With the respect to money deducted for the wages of the employees of the payment of the membership due to the labor organization, provided the employer have received each of the employee with the X account of deductions, must be assignment which shall not be revocable for a period more than 1 year beyond the termination date of the applicable collective agreement, whichever occurs sooner. 5. The respective money of one thing over the value of the trust established by the sides for representative for sole exclusive benefit of the employees, such employers, and their families dependent on such employees' family dependents, generally with employees of other employees making similar payments and families dependents, provided that the such payments are held within the trust for the purpose of the paying either the principal or of the income, both, or the benefit of the employees and family dependents, the medical, hospital care, pensions, and the retirement of the death, employees' compensation for the injury, illnesses resulting from the occupational activity, and insurance of provided with any of the foregoing unemployment benefits of the life insurance, disability, sickness insurance, accident insurance. B. The detailed basis of such payments are to be made in specified written agreement with the employer and employees. Employers do equally represent with administrative such funds do together with the neutral person representative of the employer. The representative of the employees may agree upon the event of the employer and employees group deadlock with administrative such fund, and there are no neutral persons empowered to break such deadlock. Such agreement provides that two groups shall agree on the impartial umpire to decide on such dispute, and in the event of the failure to agree with a reasonable length of time, impartial umpire decides to shall dispute, then shall one position of the either group be appointed to the district court of the United States, the district where the trust fund used as its principal office shall contain provisions for the annual audit of the trust fund. Statement of the result shall be available for the inspection by the interested party, persons and principal office of trust fund. Such other places are being designated written agreement. C. The payments are intended to use for the purpose of providing persons pensions, annuities, and other employees are made in a separate trust and with provided that the funds held in therein cannot be used for any other purpose other than paying such pensions and annuities. 6. With respect to money at one thing of the value paid by the employer of the trustee fundship, the representative for the purpose of pool, vacation, holiday servants of similar benefits, defraying costs of the apprenticeship, and other training programs, provided that the requirements of Clause B of the provisions Clause provisions and requirements of the Clause B of the provisions of Clause 5, subsection shall apply to such trust fund. 7. With respect to the money, one thing of the value paid for the employer to pool the individual fund established for the such representative purpose of A, scholarships for benefit employees, the families, and dependents of study, educational institutions. B. Child care center for the preschool schools for dependent for the employee. C. The financial assistance for the employee housing, provided that there are no labor organization employer shall be required of the bargaining establishment of any such trust fund. For refusal to do so shall not constitute unfair labor practice, provided the requirements Clause B with the proposed Clause 5, the subsection shall apply with the trust funds. 8. With respect to money, any within one thing value paid for the employer trust fund established by such a representative for the purpose of defraying costs of legal services, employee, family, dependent of the council, planning for choice, provided that the requirements of Clause B with the proposed Clause 5 of the subsection shall apply to such trust funds, provided further that no such legal service shall be furnished with aid to initiate the proceeding directed 1 against the employer or its officers against except workman compensation causes against the labor organization and the parent subordinate bodies and other officers, agents, or 3 against the employer labor organization over their officers and agents and men arising under the National Labor Relations Act amended that of this amendments or this act. B. A proceeding where the labor organization will be prohibited to defraud with the cost of legal service the provision of labor relations, Labor Reporting Disclosure Act of 1959, 9, with respect to money, one thing's value paid for the employer to plant area, the Industrial Labor Management Committee established for one more of the purposes set forth in Title Section 5B of the Labor Management Cooperation Act of 1978. The remaining subsection D and G of the Section 302 of the Labor Management Relations Act of 1947 are found in Title 29 U.S. Standard Code 186, D through G. Alright, Title 6, Miscellaneous Provisions, Investigation, Title 29, U.S. Standard Code 521, Section 601. Secretary shall have the power to believes it's necessary in order to determine whether any person that is about to violate the provision of this Act, except in Title 1 amendment made by this Act, other statutes may investigation connection therewithin, may enter such places, inspect such records, accounts, and questions as such persons that he may deem necessary to be enabled to determine the facts relatively thereof. The Secretary may report the interested person official concerning the facts required may be shown any report required by this action concerning the result, reason for the failure to refusal of the file such report, any other operation, other matter deems to be appropriate as a result of such investigation. For purposes of the investigation provided for this Act, the provision of Section 9 and 10 is relating to the tenant's witness of the production of books, papers, documents, the Federal Trade Commission Act of September 16, 1914, as amended in Title 15 U.S. N. Code 4950, and hereby applicable to jurisdiction powers due to the Secretary of the officers designated by him. Extortionating picketing. Title 29 U.S. Standard Code 522, Section 602, it shall be unlawful to carry on picketing on both about the premise on about premises of the employer for the purpose or as part of the conspiracy and further of any plan, purpose of the personal profit, enrichment of any of the individual expect bona fide increased wages and other employee benefits by taking the obtaining of the money, by taking or obtaining any money other than the value of the such employer against his will with this content. B. Any person who willfully violates the section should be fined not more than $10,000 in prison, not more than 20 years, or both. Our retention rights under the federal state laws, Title 29 U.S. Standard Code 523, Section 603A. Except as explicitly provided with the contrary, nothing in the Act shall be reduced to limit the responsibility of any labor organization, any of the officer, agent, shop steward, or other representative of the labor organization of any of the trusts within such labor organization interested under the federal law, under the laws of any of the states, except as explicitly provided with the contrary, nothing is in this Act shall be taken any with the right of the barely remedy with the members of the law of labor organization entitled under such federal law or law of any state. B. Nothing contained in Title 1, 2, 3, 4, 5, and 6 of this Act shall be construed to supersede and impair otherwise the affect provisions of the Railway Labor Act as amended with any of the obligation of right with the benefits, the privileges, immunities, any of the carrier, employer, organization, representative person subject, nor shall be contained within said titles except Except Section 505, acts construed with the confer any rights, privileges, and immunities defensive upon the employers impair the otherwise effective rights of any person under the National Labor Relations Act as amended. Or effect on state laws, Title 29 U.S. Standard Code 524. Section 604, nothing in this act shall be construed and impair with the diminish the authority of any state to enact and enforce general criminal with respect to robbery, bribery, extortion, embezzlement, grand larceny, burglary, arson, violation of the narcotics laws, murder, rape, assault with the intent to kill, assault with the infliction of grievous bodily injury, conspiracy to commit any of such crimes, service of process. Title 29 U.S. Standard Code 525, Section 605. The purpose of the act serve as summons, subpoena, and other legal process of the court of the United States with any officer or agent with the labor organization has its capacity shall constitute service upon labor organization. Administrative Procedure Act, Title 29 U.S. Standard Code 526, Section 606. The provision of the Administrative Procedure Act shall be applicable to issuance amendment with the rescission of any of the rules, regulations, any junction authorized with required pursuant to the provision of this act. Other agency, Department, Title 29, U.S. Standard Code 527, Section 607, in order to avoid unnecessary expense and duplication of the function among the government agents, the Secretary may make the arrangements for the agreements for the cooperation, mutual assistance within performance of his function under this act, and this function of any such agency may find the practicable and consistent with the law. The Secretary may utilize the facility served as any of the Department agency established in the United States over the any state political division of the state, including the service of any of the employees with the lawful consent with the such Department agency establishment, and each of the Department agency establishment of the United States authorized, direct, and cooperate with the Secretary in extent permitted by the law to provide the information facility as he may request for assistance in performance of the function of the Act. The Attorney General as the representative shall receive the Secretary for an appropriate action such evidence developed in performance of this function under the Act that may be found to warrant consideration criminal prosecution under the provisions of the Act of the federal law. Criminal contempt, Title 29 U.S. Code 528, Section 608. No person shall be punished in any criminal contempt alleged committed outside of the immediate presence of the court in connection with a civil action prosecuted by the Secretary or any other person within any of the court of the United States under the provision active unless the facts consulting with such criminal contempt are established with the verdict of the jury proceeding with the such jurisdiction of the court which the jury should have chosen and impelled to manner of prescribed law governing with the trial juries compile prosecutions in the District Court of the United States. Alright, prohibitions on certain disciplines of labor organization, Title 29, U.S. Standard Code 529, Section 609. It shall be unlawful to the labor organization, any officer, agent, shop steward, other representative of the labor organization, employee thereof, and fine, exonerate, expel, otherwise discipline of the member of the existing with any of the rights entailed with the provision of the Act provision, Section 101, applicable for the enforcement of this section. Deprivation of rights under the Act of Violence, Title 29, U.S. Standard Code 530, Section 610, it shall be unlawful for any person through the use of force of violence, threat of the use of force of violence, restrain or coerce, intimidated, attempt to restrain, coerce, intimidated any member of labor organization for the purpose of interfering with the preventing the exercise of any right to which is entitled under the provision of this Act. Any person who violates this section shall be fined not more than $1,000 in prison for more than 1 year or both. Separable provisions, Title 29, U.S. Standard Code 531, Section 611. If any of the provisions of the application for such provisions to any person in circumstance shall be invalid, the remaining of the act on the application of such provision to the person circumstance other than those as to which is held invalid or shall not be affected thereby. Alright, Title 7 Amendments to the Labor Management Relations Act of 1947 is amended. Text Section 4, 701 through 707 is not included here. However, the complete text of Title 7 Amendments to the Labor Management Relations Act of 1947 as amended may be found in Public Law 86 through 57.